I got a question for you. When did you last sign away a constitutional right without knowing it? Think about the last time you signed up for a streaming service, or clicked I agree on the credit card app, or downloaded a new phone, or joined a gym, or ordered something online. Buried in that wall of fine print, you know, the one that nobody ever reads?
Nobody reads the fine print.
There's a very good chance that you waived a right that James Madison put in the Bill of Rights in 1791. It's called the Seventh Amendment, and most Americans have never heard of it. Here's what it does. It guarantees you the right to a jury of your peers when you're in a civil lawsuit. Not a criminal case, a civil case. Your car accident, your wrongful termination, your landlord kept your deposit, your bank charged you fees it wasn't supposed to. The founders thought this right was so essential, so fundamental to keeping power in the hands of ordinary citizens, that they almost blew up the entire Constitution over it. And today, corporations have found a way to quietly route around it legally every single day. That's what we're covering today, the Seventh Amendment. What it says, why it was nearly lost before it was even written, and why it might matter to you more than any other amendment in this series.
Who is this guy?
Hey, if you're new here, let me introduce myself. I'm JP, a former Special Forces officer with 14 years of service, having deployed to 11 countries across 3 continents. There's places where the concept of a fair hearing before an impartial body is a joke, where the powerful writes the rules and the ordinary person has no recourse. The Seventh Amendment is America's answer to that in a civil context. This channel exists to give you the tools to understand what these rights are. It's not to tell you what to think about them. Let's get into it. All right, let's read it. In suits at common law, where the value in controversy shall exceed $20, the right of trial by jury shall be preserved, and no fact tried by a jury shall be otherwise re-examined in any court of the United States than according to the rules of the common law. 2 clauses. The first guarantees your right to a jury trial in civil cases at the federal level. The second says that once a jury decides the facts of your case, a judge can't just overturn those facts and substitute his own judgment. The amendment is short. It is considered one of the more straightforward provisions in the Bill of Rights. But there's a detail in the first clause that most people blow right past. $20. That threshold, the minimum value of dispute that triggers your jury trial right, was written in 1791 and has never been changed. $20 in 1791 is worth over $700 today, but the threshold is still $20. It is one of the most frozen provisions in the entire Constitution. That quirk tells you something important. The Seventh Amendment has been largely left alone. Nobody updated it. Nobody incorporated it to apply to the states the way almost every other Bill of Rights provision has been. It sits in the Constitution mostly as written, doing its quiet work, while the world around it has changed almost beyond recognition. Let's talk about it. All right, we're in Philadelphia, September 1787. It is the final week of the Constitutional Convention. The delegates have been there in Philadelphia since May. It is hot. Tempers are short. They are days away from finalizing the document that will either save the American experiment or doom it. On September 12th, a delegate from North Carolina named Hugh Williamson stands up and points out something nobody has addressed. The new Constitution contains no guarantee of a civil jury trial. There's some murmurs in the room. A few delegates say it matters. Others say that state courts are too different from each other to write a single rule. The motion to add it fails. 5 days later, on September 17th, the delegates sign the Constitution and go home. And that's when things get interesting. The anti-federalists, the people arguing against ratifying the new Constitution, were looking for ammunition. And this was a gift. Patrick Henry, the man who famously said, "Give me liberty or give me death," stood up in the Virginia Ratification Convention and argued that a federal court without civil juries was the instrument of tyranny. He wasn't alone. Across New York, Massachusetts, and Virginia, states that weren't all certain they'd ratify, the absence of a civil jury guarantee became one of the loudest objections to the entire document. Here's why it mattered so much. In the colonial era, civil juries have been one of the few mechanisms ordinary Americans had to resist British authority. When a British official tried to enforce an unpopular tax, American juries simply refused to convict, a practice called jury nullification. The jury wasn't just a dispute resolution tool, it was a check on power. The idea that a new federal government could create courts without juries, where a single appointed judge would decide both the fact and the law, felt to many Americans like replacing one crown with another. James Madison, who had originally opposed including a civil jury guarantee, saw the writing on the wall. In several states, ratification came with explicit calls for the Bill of Rights Amendment protecting civil jury trials. If there was going to be a country at all, there had to be a fix. So, Madison went to work. In 1789, he proposed a list of amendments to the First Congress. Among them was what became the Seventh Amendment. There's almost no record of debate over its text. It passed quickly, without controversy. Everyone agreed it needed to be there. By December 15, 1791, it was ratified as part of the Bill of Rights. The right that nearly sank the Constitution became one of the quietest provisions in it for about 200 years. Here's a number that puts the amendment's quiet history in context. Today, Fewer than 1% of civil cases filed in federal court actually go to a jury trial. Most are settled, dismissed, or resolved before a jury ever sees them. The Seventh Amendment right, even in a functioning court system, has become statistically rare in practice. But over the last few decades, something else has been happening. Something that has pushed that number even further from view. And it starts with fine print.
I can't see that. Better now? Or now? Well, now it's getting there. Now I can't see anything. I see.
Let's talk about the $300,000 penalty that nobody got to challenge, SEC versus Jarkessi 2024. In 2013, the Securities and Exchange Commission accused a hedge fund manager named George Jarkessi of securities fraud. The SEC had two options: take him to federal court where he'd get a jury trial, or handle it through their own internal tribunal, their own judges, their own rules, their own process. The SEC, of course, chose the internal route. Their in-house judge found Jarkessi liable and hit him with a $300,000 penalty. No jury, no federal court, no impartial panel of his peers. Jarkessi appealed, arguing the SEC had violated his Seventh Amendment right. The case worked its way all the way up to the Supreme Court. In June of 2024, in a 6-3 decision, the court agreed. Chief Justice Roberts wrote that when a government seeks civil penalties for fraud, which is at its core a common law claim, the Seventh Amendment requires a jury trial. The SEC couldn't sidestep that right by holding the proceedings in its own building with its own judges.
Justice.
The ruling mattered well beyond Jarkessi. More than 24 federal agencies have been using similar in-house tribunals for decades. Their Jarkessi decision raised a straightforward question that courts are still working through. How many of those proceedings have been bypassing a right the founders nearly collapsed the Constitution to protect? Jarkessi was about a government agency, but the bigger story, the one that affects almost everyone watching this, is about corporations. Since at least the 1990s, companies have developed a practice of inserting mandatory arbitration clauses into standard consumer and employment contracts. You've agreed to dozens of them without knowing it. Your phone plan, your credit card, your gym membership, your streaming services, your employer, possibly on the day you were hired. What these clauses say, buried in the fine print, is this: if you ever have a dispute, you cannot sue us in court. You must bring your claim to a private arbitrator, one the company typically has a role in selecting. No jury, no judge with lifetime tenure, no public record, no meaningful appeal.
See, now that's some bullshit.
How widespread is this? A 2024 peer-reviewed study from the University of Michigan found that over 97% of American adults have already entered into at least one forced arbitration agreement, and that over 99% of people who believe they've never signed one almost certainly have. Fewer than 1% of consumers in the study correctly understood that clicking "I agree" have waived their constitutional right to a jury trial. That's not a small number. Over 60 million American workers are currently subject to forced arbitration agreements in their employment contracts alone. Projections suggest that by the mid-2020s, over 80% of non-union private sector workers will be covered. And here's what the outcomes look like inside arbitration. Employees win roughly 21% of the time, compared to about 36% in federal court. When workers do win, the median award in arbitration is roughly 1/5 of what it is in a federal class action lawsuit. The arbitrators, unlike juries and federal judges, depend on repeat corporate clients for their business. The structural incentive doesn't disappear. The legal mechanism behind all of this is the 1925 law called the Federal Arbitration Act, originally designed to help businesses resolve contract disputes with each other quickly. A series of Supreme Court decisions, particularly since 2011, dramatically expanded its reach into consumer and employment disputes. The result was a quiet, legally sanctioned erosion of the Seventh Amendment for tens of millions of people who had no idea it was happening. Congress has tried to address it. The Forced Arbitration Injustice Repeal Act, the FAIR Act, has passed the House twice. However, it has stalled in the Senate both times. All right, it's worth noting what the Seventh Amendment does not do. It does not apply to the states through the 14th Amendment. This makes it genuinely unusual. Almost every other provision in the Bill of Rights has been incorporated, meaning states must follow it too. The Seventh Amendment has not been. It is a federal civil jury trial right. Most states have similar protections in their own constitutions, but the federal guarantee does not reach state courts. One more way this amendment operates quietly, mostly out of sight. The Seventh Amendment is in a complicated place. The right itself is intact on paper. If you are in a federal civil lawsuit that triggers the Seventh Amendment, you have the right to demand a jury. The Supreme Court reaffirmed that forcefully in Jarkessi in 2024. The challenge, however, is everything around the edges. Forced arbitration has effectively privatized the dispute resolution systems for tens of millions of Americans. The Seventh Amendment permits this. The courts have consistently held that you can voluntarily waive the right. The question of whether clicking "I agree" on the phone screen constitutes genuine, informed, voluntary consent of one that Congress, the courts, and federal regulators are still wrestling with. The Jarkessi decision is a signal that the Supreme Court takes the Seventh Amendment seriously in the government enforcement context. Whether that signal extends to the private arbitration context is an open question. What is clear is this: The right the founders nearly collapsed the Constitution to protect, the right of ordinary citizens to have their peers decide the facts of their disputes, is less accessible in practice than it has ever been. Not because it was taken away by force, but because it was routed around one terms of service agreements at a time. Whether that is a problem, and what, if anything, should be done about it, is a question worth asking. This channel's job is to give you the tools to ask it for yourself. So that's the 7th Amendment. A right that almost ended the Constitutional Convention before it started, quietly eroding in the fine print of everyday life, and making a dramatic comeback in federal court just last year. Next up, the 8th Amendment. Excessive bail shall not be required, nor excessive fines imposed, nor cruel and unusual punishments inflicted. 8 words that have generated more legal controversy than almost any other phrase in the Constitution, and that are at the center of some of the most urgent debates in American criminal justice right now.
Does the term cruel and unusual punishment mean anything to you?
If you found this useful, like, follow, and share with somebody who clicks I agree without reading, which is everyone, let's be honest.
Speak for yourself.
Subscribe so you don't miss the next one. I'll see you there.